Good afternoon, everyone. If I could just have your attention. My name is Carissima Mathen. I'm a professor in the Faculty of Law at the University of Ottawa, which means I'm also the lucky colleague of Colleen Flood, who very kindly asked me to chair this keynote panel. And Colleen has put together a real powerhouse duo who will, I am sure, have no trouble holding your attention over your lunch. Having had a chance to talk with them and review their work, I find it absolutely fascinating, and I'm really looking forward to the discussion. So I'm going to introduce them both now, and then they'll each have their turn at the podium, following which we'll have some time for questions. So our first speaker will be Carolyn Tuohy, who is Professor Emeritus and Senior Fellow, School of Public Policy and Governance at the University of Toronto. She specializes in comparative public policy with an emphasis on social policy. She is the author of numerous journal articles and book chapters in those areas, as well as professional regulation and comparative approaches. She's frequently consulted by government and related agencies on public policy matters, and she is a fellow of the Royal Society. Our second speaker is Katharine Young, who is Associate Professor of Law at Boston College. Her scholarship focuses on comparative constitutional law, economic and social rights, constitutional theory, and positive state obligations, among other things. Before joining Boston College, Professor Young was an associate professor at Australian National University, a visiting assistant professor at Boston University, and a Bayes teaching fellow at Harvard Law School. She has professional legal experience in Melbourne, New York, the United Nations, and an NGO in Accra, Ghana. So I'd like to welcome our panelists and invite Carolyn to take the stage.
Carissima. Normally, speakers who are addressing a crowd that's eating are expected to be more entertaining than the others on the program. I assure you that is not the case here. We are continuing with the seriousness of the conference throughout lunch. My role is to talk a bit about experience in 3 jurisdictions that I've been looking at as part of a book project that has finally come to fruition this month, I'm told. It's at the printers as we speak, and I've got flyers at the back just to give myself a plug. But I've been looking at 4 countries, Canada being one of them, but the other 3 being the UK, in particular England, the US, and the Netherlands. And the focus of the book and my own particular interest is on the politics of these reforms. So what I want to do is to draw on that knowledge base to say a bit about what we can learn about the role of private finance in market-oriented reforms in these, from these 3 countries, and what the implications might be for Canada. The dynamics of these reforms are very much driven by the clash of public and private objectives as they play out politically. And the principal point I'm going to make, the principal lesson that I want to draw, is that contrary to the expectations of many of the advocates of so-called privatization, or many of those who fear privatization, in fact, what I principally observe in these reforms is that they are less likely to weaken state authority than they are to draw private actors under the regulatory authority of the state. So let's see how that played out. First of all, I want to very briefly distinguish different types of privatization or different types of market-oriented reforms. I think this is coals to Newcastle for this group, so I'll go over it quite quickly. Market-oriented reforms can change the balance of power in the system. They can increase the role of private finance as opposed to public authority, or they can change the mix of instruments, relying more on contracting and voluntary mechanisms of exchange as opposed to command and control. These things get mixed up sometimes when we talk about what we mean by market-type reforms. And they can operate on either the delivery side or the payment sides of the healthcare system. A two-tier system, in the title of this conference, typically refers to an increase in the weight of private capital in paying for healthcare services. But I'm going to review a somewhat broader landscape as well. Looking very briefly, a very brief sketch of the reforms in each of these three countries. I'm focusing here on England. It is true that these reforms started with an application to the 4 countries of the United Kingdom. After 1999, authority over healthcare was devolved. Scotland actually reversed the reforms, and they played out quite differently in the 4 countries, but my focus is going to be on the largest of the countries of the UK, that is England. They were primarily focused on the role of contracting within the public sector, a focus on the delivery of health services, and the idea was to have public actors compete with each other, divide the NHS hierarchy into 2 wings, purchasers and providers, have them contract with each other, be more explicit about what was being sought. There was an experimentation with giving general practitioners budgets out of which they would purchase a certain proportion of hospital services and community services for their enrolled populations as well. This was called the internal market. It was continued under Labour after 1997, very much in the spirit of the purchaser-provider split. Even more independence was given to hospitals and other provider trusts, so-called, more choice for patients. And even though this was foreseen under the Conservatives who introduced the internal market reforms, contracting with privately capitalized providers did not really take off until under Labour, interestingly enough. The contracts with so-called independent sector treatment centers were undertaken in niche areas. So the NHS would publicly pay these privately capitalized providers for the provision of services. The reforms were revised, continued but revised under the coalition to focus more on the purchasing side and establish consortia of general practitioners, harking back to the original experiment with GP fund holders, to purchase virtually almost all services from independent trusts. There is now some movement toward reintegration, of course, as there always is, and the pendulum swings in the NHS. And the other story in England, Britain, that I will return to at the end is the austerity story since 2010. It's impossible to talk about what's happening in England without talking about the austerity agenda of the Conservatives. In the Netherlands, the focus was on the payment side, on insurers, not on providers. And over a 20-year period, the Netherlands moved from a bifurcated system of social insurance for the lower 2/3 of the population in income terms and voluntary private insurance for the upper 1/3 in income terms to a common system of universal, compulsory, but highly regulated and highly subsidized private finance. In the US, the so-called Obamacare reforms had essentially 3 pillars. One was to regulate the individual and small group market, to provide private insurance to those who had subsequently found it unaffordable, through an individual mandate, a version of an employer mandate, and the regulation of those state-based so-called health insurance exchanges or marketplaces within which private insurers competed and purchasers were publicly subsidized. The reforms also involved the expansion of the Medicaid program for the poor and some increased regulation of employer-based insurance, which essentially universalized the provisions of many of those plans. The material effect, this is one of the puzzles of Obamacare, which of course has been such a flashpoint politically in the US. Materially, it affected less than 10% of the population. But because it was based on mandates and increased reporting of compliance with mandates, almost everyone felt the touch of Obamacare somehow. So it was, the Republicans have been able to portray it as as an overreach by the state. So how did these reforms play out? And as I said, we observe a kind of clash of public and private objectives. If you are a private entrepreneur, there are really two driving factors that you're considering: risk and profit. If an enterprise isn't risky, it does not invite entrepreneurialism. If there's no risk, why wouldn't everyone just rush in? So entrepreneurs are those who are willing to take a risk in order to make a profit. And both of those things clash in various ways with public sector objectives of equity, stability, fiscal sustainability, et cetera. So the underlying assumptions of market-oriented reforms, and we heard something about this morning, are that they allow consumers increased choice, and that risk-bearing entrepreneurs will allocate resources more efficiently than public sector decision makers who don't have to face a bottom line. But the problem in the delivery of services such as healthcare is that it's not just the entrepreneurs who bear the risk, it's ultimately their clients. If an entity fails, that risk, or if it provides lower quality service as it struggles to survive, those risks are going to be borne by consumers as well. And therefore, why am I not getting there? Okay. Therefore, governments will typically buffer private investors against risk. As Peter Smith, a healthcare economist in the UK, once said to me, it takes a brave state to allow a private sector provider of public services to fail. You might also say it takes a ruthless state. So governments typically buffer private investors in various ways. These are ways that occurred in the three countries I'm talking about. GPs bore risk only up to the GP fund holders who were given budgets to purchase services for their enrolled populations were at risk for only a share of that. They were buffered by the state. Throughout, we've seen a kind of implicit or sometimes explicit ad hoc support for deficit spending on the part of both public and private providers. The Netherlands introduced risk for insurers very gradually over a 10-year period. Similarly, the Obamacare insurance exchange involved various mechanisms of reinsurance and risk corridors, et cetera. So if private entrepreneurs were buffered against risk, they were also somewhat limited, however, not just somewhat limited, in terms of the profit that they could reap from these systems. And here's a key point, and it's one that's often made by comparativists. Once a universal public system is in place, key condition, once a universal public system is in place, opportunities for private profit across the broad spectrum of acute care services are actually quite limited. In the first place, demand is insufficient. If it is a reasonably robust public system, demand is insufficient to sustain comprehensive private facilities, and therefore parallel private providers tend to arise only in niche areas where they can, in fact, realize some profit. And we see that in the areas of, this is not just in Canada, this is true cross-nationally, joint replacement, reproductive services, cataract services, surgery, in some cases imaging. There are some private multi-service hospitals, acute hospitals in England, but total private acute spending amounts to less than 10% of the total on acute care. And it is concentrated in the easiest to serve categories of the 30 to 64 age group. Once again, I'm having trouble getting the Okay, so the first reason for limits on opportunities for profit is insufficient demand. There are also state-imposed limits as part of the quid pro quo on buffering against risk. So we've seen throughout, various, I'll skip over that in the interest of time that I've just been reminded of, but various ways in which the state has limited opportunities for profit, largely through regulation and payment schedules. So why do private entrepreneurs get engaged if there are such limited opportunities for profit? In the first place, and the principal reason, is usually to establish market share. Market share for two reasons: to market other lines, whether it's supplementary health insurance or completely, or property and life insurance, to their clients, and also because it increases their bargaining power. The larger the insurer, the greater the bargaining power with providers. And growth is also attractive on equity markets. So if you can simply show that you're growing, not necessarily that you're actually increasing your profit margins, you will be more attractive on equity markets. What these things have done, what these two phenomena have done, is to lead to increased concentration, and we see this across the three countries: increased concentration of insurance markets and mergers and acquisitions, creating provider chains. The regulatory response there has been to ensure that these supplementary services that are offered as a result of increased market share do not become conditions of access to expedited access or de facto risk selection, and an increasing attention to guard against cartelization in these markets, so an increased regulatory response there. The growth of these large entities, however, has also created real problems of accountability, because they tend to adopt very complex corporate forms in order to find some areas in which they can shelter profits. Regulation is also driven by the fact that the boundary between public and private is very permeable. So complications in the private sector can pitch up in the public sector. That is, complications in the health outcomes of health interventions. The public component of the practice or facility of a entity that's offering services both publicly and privately funded can become a guaranteed platform. So the principal example here is consultants, specialists in the UK, who have a guaranteed public platform but can offer services privately in the parallel tier. That is essentially a public subsidy to their private practice. The potential for privately financed services to lead to expedited access, I've mentioned. And so the regulatory response here, again across all three countries, has been an increased regulation of private providers to deal with this permeability of the public-private boundary. Increased regulation of quality and safety, prohibitions on expedited access. We're going to hear more about the NHS contract from Brian later this afternoon in terms of the regulation of specialists there, required contributions to the public sector. There is, however, very little evidence of systemic effect of these responses. Okay, very, very briefly, I'm not going to go through this. This is just to point out to you that what we have seen is a proliferation of regulatory agencies, central regulatory agencies in each of these areas, regulating insurers, providers, and the markets themselves. The upshot is that private actors who were formerly less regulated because they were practicing in a kind of unnoticed Wild West of their respective systems, more or less, are now increasingly regulated. They are legitimated, as I referred to in my earlier comment. They are legitimated, but they are increasingly regulated. What are the implications for Canada? It will depend on how we respond. If we legitimate and regulate private insurance, the material effects may be less. The symbolic effect, however, I think we need to take seriously. Will this be perceived as an affront to equity? Will it erode support for the public system? In my own limited look at the international evidence, I have found no evidence that an increase in the private sector erodes support for the public sector. In fact, where there has been a increase in the level of in the private share of expenditure, we have seen subsequent public support for increases in public expenditure. So, more for discussion. Thank you.
Thank you, Carissima. Thank you, Colleen, for the invitation to be here. I'm going to be talking today about how we should think about queue jumping. And queue jumping is, of course, a slogan that's very familiar to you in the Canadian healthcare debates. But I want to impart the lesson that queue jumping is not just a slogan, it's a metaphor, it's a framing device. And it's also a concept that grounds decisions of priority and of allocation, but also embeds certain assumptions about the role of government, the role of markets, and the role of courts. At the moment, these assumptions are also embedded in a rival concept, the concept of rights. So I'm going to say a little bit about the kind of rights revolution that we're living in, with many individual interests being named as rights, including healthcare, and something about the interaction between rights and queues, which may not be obvious. And then I'm going to impart 3 examples, one of them being the Canadian one, which is very familiar to you, but a second about housing rights in South Africa and the queue talk that has developed there, and about asylum-seeking claims in Australia and the queue talk and queue jumping discourse that's very prominent in that place. So let me turn to the background of rights and queues as we presently are in. So we're definitely in a rights revolution since the Second World War. It's a prominent feature of all constitutional systems to articulate certain interests as fundamental, as worthy of protection against majoritarian decision-making, as protected against the calculations of utilitarian analysis. And these are interests in rights articulated oftentimes at the constitutional level. And here in Canada, there is, of course, the Charter. The US Constitution was the first to write down certain fundamental rights. The European Convention on Human Rights is another very prominent instrument. And of course, there are many human rights instruments at the UN level. So we're living in a rights revolution in terms of these interests being entrenched. And what that basically means is that rights play now a very big part of policy making. But also it means that rights are subject to litigation. And so it's a very common feature of rights that groups can mobilize around them, that individuals can also rely on courts to make declarations about their rights, and to expect then certain highly charged political disputes, as often happens, are settled by the courts themselves. And a third feature of this rights revolution is something that's often described as an increased rights consciousness, the idea that individuals do have entitlements to be protected against the government, and that they can be very much mobilized around the idea of their own rights entitlements, their rights consciousness. And this has been observed to have very progressive effects, but also very conservative effects depending on the place and depending on the rights. So that development has been familiar. There are very many debates during the entrenchment of the Charter here in Canada. But the new revolution now occurring is arguably in enumerating rights in the economic and social sphere explicitly. So rights to food, healthcare, housing, education, social security, child protection. These were articulated in the Universal Declaration of Human Rights back in 1948, but it's an increasing feature of contemporary constitutions, particularly since the end of the Cold War, to enumerate such rights within constitutional textual guarantees. And this brings the same trends we see of a rise in policy making around economic and social rights, a rise in litigation around economic and social rights, and a rise in rights consciousness and rights talk around economic and social rights. This is a global trend, and so the Canadian Charter, being one of the few that do not and chose not to elect to explicitly guarantee economic and social rights, lies within 17 constitutional systems that do not explicitly guarantee such rights. Every other system guarantees at least one economic and social rights, and the majority of constitutions, in fact, contain 9 or more such rights. So this is the kind of global context we're now in. Within that context, health is one of the most standard rights to be articulated. 80 constitutions now around the world contain an express justiciable guarantee to the right to healthcare, which means there will be judicial review and judicial intervention in protecting the right to healthcare. And that's a trend that's really increasing. So since the year 2000, a further 20 constitutions from 60 have entrenched the right to healthcare. And the very same critiques follow the right to healthcare as have followed economic and social rights more generally. The critique that this favours a very individualised, very litigious way of making claims upon the state. An added critique to the right to healthcare specifically has been its tendency to privilege middle-class interests because of the greater access to lawyers and to courts that the middle class enjoys. And the tendency for courts then to avoid the kind of systematic issues, but rather provide individual remedies, thereby kind of increasing health costs and really making health policy in a very inefficient and problematic way. That said, the health and human rights to health movement is not one that's based solely on litigation. There are moves to increase rights consciousness around particular access to essential medicines and so forth. And so I don't want to suggest that litigation is the only method and the only battle that health advocates and health rights advocates are taking. And the relative success or regressiveness of such litigations when they are followed really depends. There are many success stories out there involving, for example, South Africa or Brazil around the right to health litigated. But it depends very much on the fiscal realities as well as the legacies of welfare provision, in particular constitutional systems, the legal traditions, and of course public opinion. And when we get to public opinion, that's where I think it's very important to understand the role of cues. Now, cues are nowhere near receiving the same kind of socio-legal or comparative analysis that rights have received, but I would suggest that they're just as ubiquitous a phenomenon in contemporary access debates around economic and social goods and services. So let me take you through some of the conceptual questions that are very interesting when we put rights and cues on the table against each other. Rights as traditionally understood as civil and political liberties, which may require government restraint, so-called negative rights, very clearly suggest that cues should be prohibited. So if we think within that frame, we might think, well, if there's a right to be free from torture, we're not going to expect our government to desist from torturing one person at a time. That would be outrageous as well as not make any sense. So very clearly within that negative frame, it's very easy to think, well, rights should prohibit cues. Cues should not be allowed if we have a right. But to think that is to think too simplistically about how interests in human dignity and freedom and equality, which is supposed to be espoused by rights, really should be understood. And in fact, there are instances where rights not only permit cues, but also may require them. Let me say something a little bit about both of those examples. If we think about rights even to free speech, to voting, to a fair trial, we will need queues to be permitted just because these can be scarce goods that need to be rationed. So some kind of queuing system is permissible in a system which protects rights. And oftentimes then the debate will be, well, what is undue delay? How do we expect those obligations to be fulfilled? But there are also cases where rights not only permit queues, but will require them. And this, of course, becomes clear if we think about systems which prohibit a private market in the goods and services that are required by rights, such as the Canadian healthcare system, the medically necessary services. So if you think about at that context, there's many reasons to prohibit the private market. We've heard about them today because of background inequalities dictating access, because of also background discriminations which can lead to biases which challenge access, or because we think that healthcare is something that should be without a price. There are various reasons for prohibiting the private market. There are many discussions about the pros and cons, but if we are in a case in which the private market is prohibited, then we will need to require queues in order to allow access. And so those are the relations between the two which are not always fully understood in rights discussions. Now, if we flip this and look at the relations between queues and rights, on the other hand, it becomes very interesting because we see that queues not only institute rights, where rights require or permit queues, there needs to be queues to be instituted. So queues help to do that. But also queues themselves create rights. People are then given a right to their place in the line, which becomes very interesting. And they displace rights. They displace the rights of those otherwise seeking access who are not permitted onto the queue. This gives rise to a politics of queue talk, which I think really rivals the politics of rights talk. So let me say a little bit more about the queue as a concept, because I think in understanding this discourse, we really do need to understand the concept itself more complexly. So queues, of course, allocate scarce resources, but do so in very differentiated ways. We have first come, first served as a very prominent queuing discipline, but there are various other priority algorithms. I think we'll hear more this afternoon, but need can form the basis of queue priority, including clinical need, proximity, the priority given for a certain amount of waiting time. Randomized allocations can work with queues. So there's a completely differentiated way of structuring a queuing system. Queuing theory tells us a lot about those differentiations. Queues also apparently uphold values that we hold very dear, perhaps dearer than the values that we think are upheld by rights in some cases. Queues appear to be fair. They're not providing access to goods and services according to an irrelevant factor, such as race or sexual orientation. In that way, they're very like rights because they prevent an irrelevant factor allowing for preferential access. And they seem to reward everybody's time the same way. You stand in the queue, you're treated equally. So they appear to uphold equality, and people feel very much that queuing systems are equality-based systems. But I want to suggest that that can be very contingent and very much depending on who gets access to the queue in the first place and who has the resources to wait in the queue. We really need to scrutinize the ability of queues to uphold equality. Queues also apparently uphold order rather than chaos. We're very attached to them because we prefer the rule of law, we prefer predictability and transparency. That itself is also contingent depending on the queue. And queues, lastly, I would suggest, appear to uphold social integration, trust and cooperation. In fact, queuing systems, physical queuing systems don't work where social trust and cooperation is low. And because of this, there's a kind of chicken and egg argument. If you're able to queue, your society will become more civilized, more trust-based. If you aren't able, you can't. And there's a lot of very interesting anthropologies of queuing out there, historicizing the queue and attributing it to certain notions of social integration. Because of these values that appear to be upheld by the queue, which I would suggest are very contingent on the queue in question, there is a very prominent invitation to self-sanction. So I think many of you out there would have had an experience in a physical queue of seeing a queue jumper and feeling very vigilante about it and suggesting that they get back in line. This is a very common experience, and one of the great virtues of the efficiency of a queue is that it doesn't really need a centralized authority to move everyone along. Increasingly, queuing tape does that for us, but in fact, every person in the queue can be relied on to uphold and enforce the queuing norms. So that's a very interesting feature of queuing, which I suggest gives rise to queue talk, where queue jumpers are quickly called out for not upholding the norms of the queue. So let me just give 3 brief examples of where I see queue talk really taking hold in very divisive political contestations out there involving rights as well. And the first is South Africa. And South Africa's queue is its housing wait list, which is actually what a lot of elections are decided. I mean, there's only one party in South Africa, but very heated electoral debates about the role of the housing wait list, which is a rite of passage for every poorer South African who requires housing. The housing wait list was established at the end of apartheid at the same time as the new constitution guaranteed a right to housing. And so the queue is seen as the housing wait list, and queue jumpers are derided as those who try and seek priority access to housing outside of this wait list, either by squatting on vacant land or inhabiting houses and then trying to use anti-eviction laws to stay in those houses or those placements. And they're very much derided by politicians, by the media. There's a very prominent queue talk going on in relation to housing. When these cases around housing rights have been litigated, the Constitutional Court itself has been very careful not to wade too much into queue debates, although it has delineated between queuers and legitimate people seeking access to their right to housing and those queue jumpers who are trying to subvert the priority list. So it's a very interesting discourse that's taking place there around the queue. Very briefly, secondly, another discourse which is very prominent queue talk is that involving asylum seeking in Australia, again a heated political issue. The queue is understood here in its most metaphoric sense. The queue is thought to be the wait list for a placement on, for the humanitarian visas offered by Australia for those seeking asylum and seeking resettlement through the Office for High Commissioner of Refugees. And the queue doesn't really function like that if you ask any refugee lawyer. Nonetheless, it's a very prominent debate that people who seek to access entry to Australia by boat and therefore not going through these official resettlement channels are queue jumping and really need to be castigated and sent back, often detained offshore, and not ever being given access to a humanitarian visa. This is a very virulent discourse, again used by politicians, used in the media, and something that courts, which have experienced very restricted jurisdiction over asylum-seeking claims in recent years, have been very careful not to engage in. So I can answer more questions about those 2 features of queue talk. I'll just talk briefly about Canada's queue talk, and here I think you all know this discourse much more than I do, but I've read a lot of print media about it. And I have here a photograph of people queuing for the H1N1 vaccine in 2009. As far as I can understand it, the queue is the wait list and the various wait lists established for access to components of medical care. Waiting is the necessary rationing. And the queue jumpers are ascribed as those who firstly litigate their rights to establish private insurance or other forms of private care. So the Shahuli case was one in which Dr. Shahuli and his patient were queue jumpers, trying to seek private access within the public system. Secondly, queue jumpers are those who have sought to access rationed goods which have been listed out for vulnerable people and so forth, outside of the priority of that list, such as hockey players seeking this H1N1 vaccine and the scandal that resulted there, as well as politicians getting knee surgery, labour union officials getting MRIs. So there's this sense of political connections leading to queue jumping, and this is very much derided. And thirdly, those who engage in medical tourism abroad, who travel to the United States to get care, who may have to return for follow-up care in the Canadian system, are understood to be jumping the queue, getting access to certain treatment elsewhere, and then coming back to Canada to rely on the public care. And so this is the discourse that I'm tracking in Canada. And it really leads me, when we look at all three cases, to really explore what's going on in terms of this discourse and how we should really think about the slogan of queue jumping. And I suggest that what this discourse does is really hide some of the assumptions that we really should be making much more clear about the role of government, the role of markets, and the role of courts. And in particular, I think there are certain unresolved questions embedded in queue talk. And I've listed these as a preference for order versus corruption. This very much goes to the norms of the queue as upholding order. People going outside the queue as somehow engaging in illicit corruption. And this is very damaging to a public debate about healthcare. Healthcare obviously involves many of the tragic choices that have been described that society does need to make, but should always make in a very transparent and honest way. And if there's corruption going on, the norms, the kind of solidarity for public care are really being compromised. Secondly, there's an unresolved question about the role of bureaucracy or command structures versus the role of markets, and the queue talk kind of obscures the need to talk much more complexly about what's going on in each. And this is what I see in all three of my case studies, as well as Canada. And thirdly, I see this unresolved question whether the government and the accountable deliberation that we can expect from government in collaboration with expert groups and so forth should make decisions about healthcare versus courts. And those who favour the queue would prefer the deliberative process rather than queue jumping through engaging in litigation. In each of these questions, and I think all of them are in each of the case studies, I think we do need to think much more complexly about each of the dimensions of whether queues do in fact uphold order, command, and accountable deliberation or not. And more problematically, I see that queue talk very much obscures questions. It can distort the space in which very important questions, first-order questions, are debated. In the healthcare context, that would be how much should society actually spend on healthcare, what are considered medically necessary treatments and what are left off the list, what are the social determinants of health and how are they being addressed. But none of these deeper questions ever get to queue talk, because queue talk tends to fixate on priority in the line. When is it my turn? How long will I have to wait? Legitimate questions, but distorting questions. And finally, I would suggest that there are certain stakes to queue talk, that queue talk can produce certain enmity and anti-solidarity. This is particularly the case when the queue jumpers themselves are poor and desperate and otherwise stigmatised, as in the Australian and South African cases. It may be less the case in Canada, particularly as it seems norms of consumerism becoming more acceptable. Queue jumping may not be seen as problematically as the other two case studies in that respect. So the bottom line is, I think we do need to think more complexly about queues, and that the discourse itself doesn't allow us to do that. Thanks.
Oh, okay. It's on now. Great. Well, thank you very much for two really thought-provoking presentations raising important questions, important conceptual questions, I think feeding into other legal, constitutional, remedial questions. So we are a bit challenged for time, so I'm going to move right to questions from the audience. I see we have a healthy queue.
Michael Rackless, and thank you so much. Terrific presentations, as the others were at this meeting. Professor Young, I just wanted to ask you to clarify, one of your slides mentioned around queues, that it's a method to allocate scarce resources. And I was just, sort of that grabbed me. Does a queue always represent scarce resources? That not enough capacity to meet the demand, in your view?
No, so I don't. And if you're actually preventing the private market because you believe things should not be given a price, or you believe that private markets will privilege those with a willingness and ability to pay and not those in need, then you may set up a queue.
No. What I'm asking is a fundamental sort of mathematical engineering question. Is your assertion that a queue represents insufficient capacity to meet demand?
Oftentimes, queues are established because the delivery point, there's a scarcity at the delivery point, not necessarily a scarcity in the underlying good or service. So it's at that point of access that there's scarcity. So the underlying good may not be scarce. This comes a lot, in physical food queues and so forth. So that wouldn't be my assertion that we're always dealing with scarce resources. There is a scarcity at some point in the delivery system, but it may not be related to the underlying good or service. It may be in point of access.
To be continued.
Hi, my question is for Professor Tuohy. I just wanted to probe a little bit more into this idea that market-orientated reforms draw private actors under the umbrella of state authority. So I'm from the UK, where these market reforms in the NHS have been subject of massive criticism for lacks of accountability, which you discussed, patient safety, but also the incurrence of debt for the public purse. And I know that you talked a lot about clinical examples, but I wanted to ask you about this through the lens of public finance initiatives in the UK, particularly because they have a very clear parallel with P3 projects here in Canada. So private finance initiatives have seemed to have accumulated huge public debt and be very cost inefficient. I think a recent Guardian article estimated that about 200 billion pounds worth of debt has been accumulated through these projects. So I guess I want to ask what this accumulation of debt through PFI projects say about the ability of the state to regulate private involvement in the public healthcare and limit profits. And also if there are any comments on the implications for Canada with the proliferation of P3 projects.
Mm-hmm. Good, thank you. And no, I did not, for reasons of time, I was not able to get into the PFI examples. And I think they are, and let me wrap the Circle Health example into this as well. Circle Health was a private, very complex private corporate structure that took over the running of an NHS hospital and failed. And so and taking together the various problems with the PFI initiative and the failure of Circle Health, I think what we're observing now is an increased focus on regulation and an increased focus on contracting in the UK. That was an extremely unfortunate way to get there by observing the failures of these public-private partnerships, whether they take the form of PFI in capital projects or whether they take the form of contracting with a private hospital provider in the case of Circle Health. But we are observing a regulatory response now and an increased focus on those contracts.
What would you say about kind of the fact that similar problems have been levelled at P3 projects in Quebec and Canada more generally, and also the fact that they involve a lot of the same international actors, such as Caroline, who recently went bankrupt, incurring huge public debt?
Yes. Well, proceed with caution. Yes. I mean, I think there are indeed cautionary tales from elsewhere. I wouldn't say don't proceed at all, but I would say proceed with caution.
Thank you.
Sarah LaBelle. I just want to raise a study that was done by the Ontario Health Coalition. It was done in a period, and I realized that you didn't do a comparison of Canada. You used like the UK and the US on your evaluation. But in Canada, from a period of August 2016 to the spring of 2017, 136 clinics were surveyed across Canada. And what the Ontario Health Coalition found out was that in Alberta, 8 out of 13 clinics were charging user fees. In British Columbia, 30 out of 34 were charging user fees. In Nova Scotia, 4 out of 5 were charging user fees. And in Ontario, 12 out of 14. Quebec, 17 MRI plus 14 others, so that was 31 clinics in total, charging user fees. In Saskatchewan, 3 out of 5. So in total, 88 clinics out of 136 were charging user fees, and these were for medically necessary services. So when you mentioned on your slide the assertion that opportunities for private profit are typically limited, I'm just wondering what data was used to come to that conclusion, whether it's an assumption that happens that it gets restrained by having a single payer system, or whether you were able to access information like that and this was just the Ontario Health Coalition survey was just limited to user fees. It didn't include double billing, it didn't include upselling of services, and it didn't include ordering tests and diagnostic services that weren't clinically indicated. So I'm just wondering what data was used for that.
To legal profit, the examples that you give are not legal under under the Canada Health Act, if they're for medically necessary services. This is my principal concern about the Canadian system, that by assuming that it is the power of the public purse that we will continue to use to ensure equity, and turning a blind eye to private finance in the system, we are ignoring the power of regulation. And if we were to fully utilize the power of the public purse, maybe that would work. But the fact is that we have, by assuming that we can do everything through public finance, we have allowed a Wild West to grow. And it would be more sensible if we were to to use the full instrumentality of the state, not just finance, but regulation, and address exactly the kind of issue that you're describing with the charging of user fees, and other elements of private finance in the Canadian system. So the cases in, I mean, I can give you the bibliography if you want to see me later, but there have been studies in the Netherlands, in the UK, not the US. The US does not fall into the category that I'm describing, where there is a robust public system. Remember the condition that I set out at the very beginning. Where there is universal health insurance, there are limited opportunities for private profit across the full spectrum of acute care. This is not the case in the US, but in the UK and the Netherlands it is.
Hi, Adam Houston. This is a question for Professor Young. I'm just wondering, in terms of this queuing conversation, I mean, can we really compare a situation where we get in line, ultimately everyone's rights will be realized, but with potentially some inconvenience, but at the end of the day, it'll work. Like, to analogize just now, this long queue for lunch, it's a system I trust. I know that when the Health Law Center organizes something, I know Giles orders enough lunch. So if I get there, I'll get my sandwich at the end. If there were half as many sandwiches, we might behave differently. Whereas, South Africa, right? We talk about the, housing case, Grootboom, great, realizes right to housing, but right, Irene Grootboom, died quite a few years later, having never actually received her house. In that kind of situation, it's probably understandable that people are going to compete for those scarce resources when there's a very good chance that if you're in the queue, you're not going to get it. So I am just wondering how comparable those situations really are, given that difference.
Yeah, there's certainly a big difference between what's called entitlement determining queues that your priority actually means whether you get the good or you don't, and they're a lot more anxiety provoking, obviously, than queues that simply order the timing of your delivery. So there's a lot of literature on waiting experiences and queuing norms that do differ depending on whether the queue is entitlement determining or entitlement ordering. We would hope that the healthcare system in Canada is an entitlement ordering rather than entitlement determining system. As it's portrayed in the US discourse, it's entitlement determining. These are the Obama death panels that are thought about. If the public system is providing the priority decisions of the queue, your ability to live or die is determined by the state. I think that's not the case with Canadian healthcare. There are wait lists. You're shaking your head. People do die on wait lists. I do read that. But I don't think it's the prominent horror that it's portrayed in the US. And oftentimes it's not their wait that, there's a complex decision about that. But you're right that different queuing systems, it's very hard to generalize and say queues are good or queues are bad without seeing how they operate in context and understanding how they're operating in context. And that distinction is a very big one. In relation to the Grootboom decision and the housing rights, there is a huge problem with the wait list in South Africa. And the problems extend to corruption, extend to bad priority, bad data management, and so on. The problem is not so much judicial involvement, because courts have been very careful not to award individualized remedies and let someone like Irene Grootboom get ahead in the wait list. So her remedy was negotiated during the trial. It was access to an arrangement that would not give her these RDP houses, her and her community, but would give her a form of housing in which she was on for 8 years, and then she passed away. Many people say housing rights aren't working in South Africa because she died without a house, but I think that misunderstands the big effect the decision had on people living in vulnerable crisis conditions. The housing policy was changed quite drastically, although it took 4 years. The court prodded that change through the Grootboom decision. There's been a series of other housing cases now where courts are very careful in designing the remedy so they're not rewarding queue jumping by access to courts, but are nevertheless seeking to change a really badly run housing system.
Hi, thank you. Good afternoon.
Quick question and quick answer.
Okay. I'm Avi Bourgeois. I'm here at the Telfer School of Management, and I think this is an important conversation for us to engage in regards to queuing. I would like us to exercise some caution because there's a lot of complexity, as you pointed out. Some cautions in the analogies that we use, because first of all, the wait lists around healthcare are often not visible. We don't see the people ahead of us, waiting in line, so there really isn't an opportunity for self-regulation. I really like the term that colleague Donald Light has used about waiting pools. They are not linear. People are in the pools and they kind of get picked up, whenever they start getting into crisis situations. And so it isn't linear. It often is invisible. And because of that, a lot of these decisions are made at the coalface. where physicians and other healthcare providers are making those decisions, and we don't see that going on. I mean, we see it if it comes into the media because it's somebody, who's prominent. But, our neighbor who's down the hall, we don't see about those. And so it brings into focus the issue of regulation. So then we need to bring a whole regulatory regime to focus on that. So then we have costs of that regulation, in addition to the cost that Colleen mentioned, the cost of subsidizing people purchasing. There's an invisible cost to this regulatory regime. And what is the focus point of the regulation as well? Is it the patients who are in the queue? Is it the providers who are essentially jumping the queue with the patients? Or is it the industry? Who are we regulating? What regulatory instruments are we using? And I also want to bring up the issue of efficiency, because I didn't ask the question earlier, but it just came to mind, especially in the work that you were presenting in the US, Carolyn, that some of the interviews that were done, qualitative interviews with physicians working at the coalface in Canada and the United States, and the physicians were saying, I can't gain any efficiency in the United States. I have these 30,000 different policies, and then all of those policies change rules. So I can never gain any efficiency in the time that I'm doing care. And you contrast that with, yes, we have a single payer system in Canada. Once you learn those rules, a more seasoned physician has some efficiency they can get people through. So these are other layers of efficiency that having these layers of complexity happen. So I'm just wondering whether or not you'd like to speak to the comments of visibility, regulation, and that efficiency at the coalface.
1 minute. So I agree that this Q Talk really obscures very important conversations and important questions, like the ones you mentioned. But I think the analogy with physical lines and the intangible, invisible lines is a very important one. So I've done some work on narrative theory and metaphor and how our cognitive structures are embedded in what we see. A lot of the stories of Q jumpers are individualized stories of people seeking successful care in the United States, and that speaks to people's sense of their right to their place in line. So there's a lot going on when people do engage in this discourse. It is an obscuring discourse, I agree, but I think we do have to take it seriously and understand it. I think we're in agreement.
Yes. So let's be clear that administrative costs in a single payer system are way lower than they are in a multi-payer system. Just let's take that as having been fully demonstrated. My concern, and let me just say probably, I don't know, for the third time now this morning, is that we are letting that ideal of having all health services within a single payer system get in the way of realizing what we can on the ground. We are not, I mean, we are struggling even to extend the single payer system to prescription drugs, have been struggling arguably since it was first adopted. So do we continue the quest for the holy grail of a single payer system across all healthcare services, or and meanwhile allow a kind of frittering away at the edges as services bleed off where they are profitable, in those niche areas where they are profitable, into an unregulated private sector? Or do we say, okay, we're going to recognize that we have private finance in this system and we're going to regulate it? That's fundamentally my argument. We ought to be realistic about what we can achieve.
Yeah, just one very quick comment. I absolutely agree. I just would want us to make sure that we have an open and honest conversation of what all the costs are involved, and if we were going to be regulating that we make those costs visible and that be part of the public discussion. Yeah.
So I'd like to thank the audience for very pointed and challenging and great questions, and of course to thank our panelists for just wonderful interventions. Thank you very much.